Good day, Trinidad and Tobago, the Caribbean, and the world. Welcome to this week's episode of Strictly Legal on WESN Content Capital. I am your host, Rondell Dono, attorney at law. Once again, I'm happy to bring the law and you. Of course, you can stream us at WESN CC on traditional media and social media, as well as our podcast at Strictly Legal with Rondell Dono. Today's discussion will take place of 2 episodes because it's so interesting, as well as it's a lot to discuss. And we are going to discuss the issue of should the CCJ, that is the Caribbean Court of Justice, be adopted as the Commonwealth Caribbean Final Appellant Court. This is a very controversial topic, particularly in Trinidad and Tobago. And I have an international guest, none other than Professor Leslie Thomas, Queen's Counsel, who is a leading human rights barrister at Garden Court Chambers. He is the head of chambers at JC Legal Solutions Incorporated, Antigua and Bermuda. He has an international practice and is called to the bar in many Caribbean jurisdictions, including Antigua, Barbuda, Dominica, Grenada, and has appeared in St. Kitts and Nevis. He was awarded Legal Aid Lawyer of the Year in 2012 and 2016. In 2020, he received the award for Outstanding Contribution to Diversity and Inclusion in the UK Chambers Bar Awards. And since 2020, he is a professor at law at Gresham College and visiting professor at law at Goldsmith College, London, Law School, University of London. He is currently representing many Grenville fire victims and survivors. Professor Thomas sits on the Equality, Diversity and Inclusion Subcommittee of the Inner Temple and is a member of the Bar Standards Board of England and Wales, and he also sits on its Race Equality Task Force. Fortunately or unfortunately, I am a member of Lincoln's Inn. However, we welcome my Inner Temple brother. Good morning, Professor Thomas. How are you?
Good morning, and Rondell, it's a real pleasure to be here.
And of course, in your side of the world, it's afternoon. So we welcome you and we thank you for gracing the Strictly Legal set here in Trinidad and Tobago.
Thank you. As I say, real pleasure. It's an interesting topic that we are going to look at and debate this today.
Now, of course, the topic of discussion is should the Caribbean Court of Justice be adopted as the Commonwealth Caribbean Final Appellant Court. And of course, bringing some context into light, we are currently, or at least Trinidad and Tobago's highest appellant court at this point in time is the Privy Council for the majority of appeal matters. Now, if you can just give us some historical context of the Privy Council and how we have arrived at now the Caribbean Court of Justice.
All right, yeah, I'm quite happy. This is just a small history lesson, as it were. But you see, the Privy Council goes back hundreds of years. It originates from the power of medieval English kings to administer justice with the advice of their council. It's been documented to go back as far as the reigns of the Norman monarchs, and where the English crown was advised by a royal court, which consisted of magnates, ecclesiasticals, and high officials. And the body originally concerned itself with advising the sovereign on legislation, administration, and justice. Then, over time, in the UK, the House of Lords then became the highest court in England. And but the King, with the advice of the Privy Council, continued and served as the highest court in the Channel Islands, which were ruled by England, but were not part of England. And then as the British Empire expanded and England acquired colonies and protectorates abroad, the Privy Council served as the final court of appeal for the colonial courts. So you can see the expansion, the expansion was so great that by the early 20th century, it was the highest court for a quarter of the world's population. Then things began to change. In the 30s and 40s, certain parts of the British Empire, known as the Dominions, became increasingly self-governing. These included countries like Canada, Australia, South Africa, and New Zealand. They decided to have their own Supreme Court. The same year, in 1931, India followed suit when it became fully independent. South Africa abolished the Privy Council in 1950. Australia abolished it in 1986, followed by New Zealand, which established its own Supreme Court in 2003. And so in the post-war decades, many of the territories which had been British colonies achieved independence within the Commonwealth. Some of these kept the British monarch as head of state, represented by Governor General, and others became republics. So, for example, Trinidad and Tobago and the Commonwealth of Dominica. However, the Judicial Committee of the Privy Council still serves as a final court of appeal for many independent Commonwealth countries, and those include Bermuda, the Cayman Islands, some British overseas territories such as Anguilla and Montserrat, and as I say, some of the other Caribbean islands.
Now, the Caribbean community has attempted to what you call formulate the Caribbean Court of Justice as the highest court of appeal in the Commonwealth Caribbean. Though it has been marred with a lot of controversy in terms of, particularly in Trinidad and Tobago, whereby this is where the court sits. And of course, we are not fully signed on as the as the final appellant court. Now, can you just draw a reference in terms of what is the Caribbean Court of Justice and what are their functions as opposed to the Judicial Committee of the Privy Council?
Yes, of course. So the Caribbean Court of Justice, or CCJ, was established by international agreement, which entered into force in July 2003. And as you say, it was set up in Trinidad and Tobago in 2005. And it has two main functions. Firstly, to resolve disputes between member states of the Caribbean community, or CARICOM. And secondly, it was set up to replace the Privy Council as the highest court for the members of the Caribbean or Caribbean community. And so, that's essentially what its function is.
And so continue, sorry.
No, I was going to say, so the first function is very similar to the European Court of Justice, where there may be disputes between member states of the EU. So that forms a similar function.
And so that's in terms of the various jurisdictions, such as the criminal jurisdiction and the civil jurisdiction. In terms of Trinidad and Tobago, I mean, a lot of persons may not know, but is there a particular type of matter that the CCJ can hear as a final court of appeal in Trinidad and Tobago?
Yes, it can. Effectively, the way it works is most Caribbean countries, or most countries in the Commonwealth, have a system whereby cases are heard in the first instance by a local superior court, generally called the High Court. And then and that might be criminal cases or civil cases. Then if there is an appeal, the first appeal generally goes to a court of appeal, in the Eastern Caribbean. Several of the countries have what they have as the Eastern Caribbean Supreme Court. And then there's a final appellate court of appeal, or Supreme Court. And as I say, for some of the jurisdictions, that final appellate decision, whether it be for criminal cases or whether it be for civil cases, will go to the Judicial Committee of the Privy Council. I'm just going to say Privy Council as shorthand, or to the CCJ, the Caribbean Court of Justice. So that's how it effectively functions. It's a final court of appeal for both civil cases and criminal cases.
Now, I know in particularly in Trinidad and Tobago, criminal appeals still go to the Privy Council.
Yes, that's right.
And of course, the contention right now is having all appeals go to the Caribbean Court of Justice. And of course, that now involves a lot of political decisions, and it's partisan politics. Now, what do you have to say about the whole controversy in terms of whether or not judges can be impartial when it comes to hearing final decisions in the CCJ?
Okay, so I think it's important to set out some of the arguments as to why there is this controversy about the CCJ. And it's really interesting. So on the one hand, those who argue for the CCJ often argue for the necessity of breaking away from colonial rule and establishing a distinctive Caribbean jurisprudence. And, you know, there have been some distinguished scholars and commentators over the years that have long argued that the time has come for the Caribbean community to adopt and use the CCJ. In fact, in 2018, following the referendum in Antigua and Barbuda and Grenada, when both of those countries, those islands, rejected the CCJ, Simon McIntosh, a distinguished scholar, said, so long as, and this is a quote, so long as we remain subjects of the British Crown with its judicial committee as the apex in the hierarchy of our legal system, it is to be expected that our constitutional discourse will reflect a cluster of values, intellectual orientations and practices that carry a distinct British cast. Our constitutional conversation is carried out in a foreign voice. We are either silenced or are constrained to speak within the institutions and traditions of interpretations of a colonial constitutions that have been imposed on us, end quote. Very powerful words. And in fact, you know, others have argued about the embarrassment that particularly Trinidad has, bearing in mind that CCJ is based there and the fact that the CCJ hasn't been adopted. However, so those are the arguments which form the part of those who endorse the CCJ. But on the other hand, there are those who argue several things. Firstly, they say that there's real difficulty because, you know, it's been said that the CCJ takes on judges from the locality in the region. Those judges tend to be quite close to the politicians and the government, and therefore, so the theory goes, the CCJ lacks, or there's a potential that it lacks independence. What's interesting, and I know we will come on to this, the proof of the pudding is in the eating. And when, you know, I decided to tackle this topic for one of my Gresham law lectures, should the CCJ be the final court of appeal? And, well, I'm going to say, and we'll come to, when I did a comparison of the cases, some might be surprised as to the result, but we'll come to that. The other thing I should say, which I think is really important and should be stated, is the fact that part of the controversy comes with the politicalization of the CCJ. It's become, in many Caribbean islands, a big part of the politics, which makes it very difficult for the CCJ to be adopted, because it has become such a political hot potato. I know that certainly in the Antigua and Barbuda referendum, the CCJ was supported by the government, and the opposition did not support it, and so it went down party lines, which makes it very, very difficult for the court to be adopted. And again, I'll explain the reasons why.
And this is the problem, if I may. This is the problem with especially the Caribbean, Trinidad and Tobago, and up the islands, is that everything boils down to party line. And what is interesting enough is that when one party is in power, they advocate for the CCJ, but when they're in opposition, their tune changes. How that can be.
And there's a real irony here, because I always say the proof of the pudding is in the eating. And when you do an analysis, the irony is, as we will see, many of the governments who have been advocating for, when they're in power, for the CCJ, are the very governments who have been supported and protected by the Judicial Committee of the Privy Council, particularly on constitutional cases. And that I found quite surprising and ironic. But as I say, I will come to those cases in a moment. I think it's also important to say this, because a legitimate question is, why are the Commonwealth Caribbean states so slow to adopt the CCJ? Yeah.
Yes.
And I think the first thing to say is that the proposals for constitutional reform in the Commonwealth Caribbean are usually rejected. The Commonwealth Caribbean constitutions are generally strongly entrenched and can only be amended by means of a referendum. And some of the countries require what's known as a supermajority. And here's the irony. Whereas in the UK, when they had the referendum on Brexit, you'll remember that only just scraped through. I think it was like 51.8% of the population voted for Brexit, 49.2% voted against Brexit. But Brexit, this thing that had, drastic constitutional implications for citizens of the United Kingdom, got through on what I describe as a simple majority. You would have thought that if a simple majority is good enough for our former colonial master, it would be good enough for many of the Commonwealth Caribbean countries. But oh no, in many of our constitutions, you can only make changes with a supermajority. So you need the vast majority of the voters to vote for it, which makes it very difficult for a government to pass constitutional change without opposition support. And as you've already indicated, Rondell, usually that is not forthcoming. But I think it's also fair to say opposition to the CCJ isn't necessarily just stubborn political partisanship. As we've touched, one of the common arguments is about political independence. And as we've just discussed, Commonwealth Caribbean politics tends to be bitterly adversarial, something which is exacerbated with, the winner-takes-all nature of the Westminster parliamentary system, which many of the Commonwealth Caribbean countries have. And thus, that partisanship often finds its way into the conduct of litigation, and many of the cases before the courts therefore have a political angle.
Particularly in Trinidad and Tobago and let's say Guyana, countries that has various ethnicities, you find that it is polarized down by race, religion. So it's not only about who party you support, but there's also a lot of politics, as you say, or adversarial type politics, or rather politics that is so personal to each side to appeal to their bases.
Absolutely. And when you have that sort of partisan, tribal, party politics, what you find is the best decisions for a country are not made because the best decisions for a country might not be popular. And, you know, as we've seen, particularly, and we can see it in America with American politics at the moment, with that same type of tribalism between the Democrats and the Republicans, decisions are made which are not in the good of the majority of the people. But that's at the expense of populism, or short-term populism, I should say.
Now, let's look at the countries the states that have adopted the CCJ as the highest court of appeal in totality. We have Guyana, Barbados. Are there any other Caribbean community states that have adopted the CCJ?
There are four. So the four are the two you've just mentioned, and Belize and Dominica. Now,
if we are to compare or contrast, and we have seen a number of decisions that have been already decided, I have not recalled, or if you can correct me, any controversy relating to whether or not these justices of the Caribbean Court of Justice were biased in their decision making. So therefore, how that can be an argument?
Yeah, it's interesting, isn't it, that there are these myths and folk tales that come about, and when you try to scratch the surface to find out whether there's any substance or justification to them, it's lacking. And I find that really disrespectful to the CCJ. The CCJ has been an absolutely fantastic court which turns out judgments which are equal to, if not better than, some of the decisions that the Privy Council has made. And and I will justify that, I will back that up in a while, why I say that. And I say that particularly having regard to constitutional and fundamental rights. The CCJ has been, to my mind, a greater protector of those constitutional and fundamental rights. And here's the thing. These are rights which tend to be the sorts of rights which are not popular, or governments don't push, or governments are opposed to, and yet still, when one looks at these cases, the CCJ has not balked or recoiled at the enforcement of these rights over and above the arguments that many Caribbean governments have tried to put forward. And if that of itself isn't sufficient evidence that the CCJ certainly in recent times has not proven itself to be independent, then I don't know what else it would have to do, which is why I feel that the CCJ have received an unfair press. And I challenge anyone, if there is an argument as to, with evidence.
And of course, these are arguments without evidence, because we have not adopted the CCJ, and therefore all these arguments to say why is it that we should not adopt it is circumstantial.
Well, I wouldn't even give it the title of circumstantial. I wouldn't grace it with that, because the evidence is just lacking. It's just lacking. It's, as I say, it's a myth. If someone can point me to a case where they can say that there was bias, there was, clear evidence by the CCJ of, taking a position where they, or corrupt decision, bring the evidence forward. But I haven't seen anything like that, and that's the thing. And let us not forget that, it's rather disrespectful to the lawyers and attorneys in this region to think that somehow they are second-rate and cannot compete or give judgments in the same way as the Supreme Court justices who sit on the Privy Council. I think just in terms of balancing the argument, what might be argued against that position is not one of independence, but one that because the Privy Council adjudicates on a huge, broad level of different jurisdictions, not just Caribbean jurisdictions, the breadth of cases dealt with by the judges who make up the Privy Council embraces a staggering amount of complex law and encompasses a wide-ranging subject area. That was an argument that was put forward by a friend of mine, actually, Desiree Artise, who does a lot of Privy Council work and who's a barrister in the United Kingdom. And
if you will, if I may, as you mentioned, a friend who has that view, there's also a Queen's Counsel in the United Kingdom who practices extensively in Trinidad and Tobago, has been an advocate for the Privy Council, and he would have commented under one of your posts, I believe, or one of the articles, and if I may read it, where he states, "Those who have practiced extensively in Trinidad and Tobago, especially in cases against the state, and seen firsthand how public institutions have become politically aligned would disagree," meaning disagree that the CCJ should be adopted. "The damage done by the processes used by the JLSC, that's the Judicial and Legal Service Commission, in judicial appointments in TT, and one judge being allegedly pressured to resign, that had led to 2 appeals to the Privy Council, merit reading and would inform one's perspective. There is no one size fits all, and it may be that the perception and concerns about the judiciary, example Barbados, is not the same as TNT. The fact that one CARICOM country independently decides to embrace the CCJ is irrelevant to whether another should. Local conditions are paramount, and of course, TT appeals are a regular presence at the Privy Council, so cost and locations are largely non-issues, especially where many now appear by video link, having chosen to do so." And this is Anand Biharilal, Queen's Counsel. He was on my program previously about the Queen's Counsel. I want to get that your perspective on that particular issue.
Well,
or comment.
I mean to say that what I would say is, firstly, I come back to let's look at the decisions that the CCJ has made in recent times, and let's compare and contrast those decisions with decisions made by the Privy Council, and let's see, let's test the argument to see whether or not, external pressures have influenced the CCJ's decision making. And as I say, I can't see any evidence that that's happened. Although that's not to take away, what the Queen's Counsel has said. The difficulty I have is I don't practice in Trinidad and Tobago, so I don't know what the local conditions are on the ground. All I can do is look at the decisions that both the Privy Council and the CCJ ultimately come out with. But I'm not going to comment on what I'm ignorant of.
But Professor, I know we have those explanations of those cases to put forward your point, but I believe we will have to wait until next week for the viewers and the listening audience to hear exactly those arguments. So join us next week, Professor. Thank you so much. I know you'll be here next week. So join us in our other episode when we go further into the Caribbean Court of Justice being adopted as a final court of appeal. You have been watching Strictly Legal on WESN. See us for part 2 next week.